Jury selection in the George Zimmerman second-degree murder trial over the shooting death of Trayvon Martin begins on Monday. The judge in the case has ruled that the identities of the jurors will remain anonymous throughout this trial, which is expected to receive huge attention worldwide. One who knows what it's like to feel the pressure of being involved in a very high-profile case is celebrity attorney Gerald Shargel, who spoke earlier with Arise News anchor Debbie Turner-Bell.
From what I understand, it was made on the application of the defense lawyer, which is very, very unusual. I've never seen or heard of that before. This is a motion that's usually made by prosecutors. It's made in terrorist cases and organized crime cases to keep the jurors anonymous, to prevent jury tampering. I don't see what it gets the defense. There are defense lawyers who argue that an anonymous jury undercuts the presumption of innocence. So it's interesting that the defense asked for it in this case. I don't know what they're trying to achieve.
Well, they've been doing some very interesting things in the last couple of weeks in the run-up to this trial. Of course, they released all of this information that seemingly is disparaging to Trayvon Martin. I think, knowing that the judge was never going to allow it, but sort of, if you will, taint the potential jury pool.
You're absolutely right. I mean, these allegations about marijuana use, as if you were talking about crack cocaine, the allegations about selling a drug selling a gun in a state where gun possession is liberally allowed. The idea that this somehow is relevant to what happened that night is, I think, ridiculous, and the judge is excluding it from the trial.
Let's talk about one more thing as it relates to the jury, and then I want to go to strategy. With this ruling that the identities of the jurors will be kept anonymous, does that also then connect to the likelihood that they're going to be sequestered as well?
Sequestration has become more and more rare. It happens very infrequently. The case law on the subject says that an instruction by the court not to read anything in the media, not to go on the internet, is followed. I believe that instruction is followed because I believe, particularly in high-profile cases, but in all cases, that jurors rise to the occasion.
And you certainly are no stranger to high-profile cases. There's a long list here of them, not the least of which is John Gotti, Jeffrey Chadro, Joe Halderman, Daniel Pelosi. So tell me a little bit, what's going through the mind of this defense team, particularly the lead defense attorney, in these days running up to the start of this trial? What are you thinking about, especially as it relates to how much attention this is going to get in the media?
Well, first of all, the defense of a criminal case is a fluid proposition, so it's not like you're locked into a position that you're never going to change. So clearly, they're thinking about strategy, they're thinking about cross-examination, they're thinking about the testimony perhaps the testimony of the client. All those things are going through their heads, and this is a very key and intense time for a trial lawyer.
And who benefits most from this public attention, the defense or the prosecution?
I think that the defense benefits to some degree. It's not the prosecution. I mean, if the prosecution has evidence that had never been heard before and it gets out in the media and there's the danger of jurors not following the judge's instructions, that's one thing. I don't think that is a problem. I think that the real issue is, and this is why I say the defense may benefit just a little bit, but why the defense may benefit is because jurors will recognize that this is, and have recognized already, and everyone knows it who's being called for jury selection, they recognize that this is a very, very important case with wide significance, and as I said a moment ago, they'll rise to the occasion.